Good evening, everyone. We'd like to call to order our work session tonight, January the 5th at 3:30 p.m.
5:30.
I mean, I missed the 3:30 one, so we're doing it at 5:30. Mrs. Hernandez is not able to attend, so that's why I'm speaking here tonight. If we could stand or have the roll call of members, please.
Yes, ma'am. Mr. Orozco?
Present.
Mrs. Paez?
Present.
Mrs. Cameron?
Present.
Mr. Crow present.
Thank you. We do have a quorum. All right, if we could stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico, the symbol of perfect friendship among united cultures. Okay, I would entertain approval of our agenda for the night.
I make a motion that we approve the agenda tonight.
Do I have a second?
I'll second.
We have a motion and a second. Roll call, please.
Yes, ma'am. Mr. Orozco?
Yes.
Mrs. Paez?
Yes.
Mrs. Cameron?
Yes,
Mr. Crow, yes.
thank you. We do have a quorum. Presentation number 5 and discussion of the New Mexico School Boards Association Policy Service. Superintendent Chavez?
Yes, Madam Vice Chair, members of the board, we have Mr. John Kennedy. I think he's well known across the state for all his work with schools in the past, and so welcome. He wasn't able to attend in person today, but we'll be here in the future to kind of talk about to go through the policy service through the New Mexico School Boards Association. And I think tonight is just an introductory, and Mr. Kennedy, I'll let you kind of give an overview of where we're going and what this is going to look like. But it is a work session, so feel free to ask questions and give comments and all through it. So, Mr. Kennedy?
Can you hear me?
Yes.
Okay. I'm here because about a year and a half ago, Joe Guillen, who is the director of the New Mexico School Boards Association, asked me to take over the NMSBA's policy service when Don Williams, who was in the previous policy service director, died. Don was from Arizona. He had initiated a policy service for the Arizona School Boards Association based upon the model policies that were distributed beginning probably 15 years ago by the National School Boards Association. New Mexico began participating in the model policy service through Don Williams and Joe Guillen probably 10 or 12 years ago. When Don died, Joe asked me to take over that function. I'm a retired lawyer, as you know. I practiced law here in Santa Fe in a statewide practice representing school districts across the state for about 43 years before I retired. And Joe wasn't going to let me go. So it's my pleasure to be here with you tonight and introduce the New Mexico School Boards Association Model Policy Manual. Let me just ask first whether you have had any introduction to the policy manual or whether you would like me to spend 10 or 15 minutes simply describing what it is and what it will do for you.
Would you like to hear that introduction?
I haven't looked at it, so. I mean,
Yeah,
Yeah.
we've all looked at it. I think, I feel funny calling you Mr. Kennedy from way back, John, but everyone seems comfortable, so.
Okay. Basically, the policy service is a model policy manual. It is based upon legal standards. It's based upon common educational practice and philosophy, and it's divided up by classifications or subject matter. There's actually 12 separate subject matters. And it starts out with basic commitments. It starts out with board governance. It has a fiscal management section, personnel, instructional issues, students, and relations with other educational agencies. That's simply a thumbnail of the categories of topics and policies that are contained in the model policy manual. The model policy manual is 1,035 pages long, which my style as an attorney was usually to focus on less is more, to abbreviate things when they can be abbreviated. And one of my tasks that I have told Joe Guillen that I will be taking up as the new policy service director is to abbreviate this policy manual somewhat to separate the wheat from the chaff and get it down to a manageable size. I think it's too long, it's too big, and some issues are, I'm not going to say there's anything bad about it. It's just, it needs to be cleaned up a little bit. And I'm in the process of doing that. I have not finished that task. I've done some cleanup, but it's going to take me a little while to do that, given that it's 1,000 pages long. To the extent that the policy manual also contains, excuse me, regulations and exhibits, the idea here is that if there's a policy that is incorporated into the policy manual and it needs an implementation guide, a regulation that the superintendent or the administration can use to carry out the principles stated in the policy, regulations are provided, and those simplify your task because it simply tells the administration what to do. The board's role, as you know, is a policy-making body. And so in drafting policy, the school board is required to basically state the what and what it is that we consider to be the guiding principles, the guiding philosophies, the guiding structure of how your school district is going to function, is going to operate. And the regulations then answer the question of how is that to be done? It gives more detail and directs particular officials of the school district what to do in order to, assure that the board got it right. Then there are also exhibits. Occasionally, there isn't an exhibit or a regulation with every policy, but the exhibits are sometimes, for example, if there is a requirement for a parent release before a student goes on an activity trip, the policy manual provides you a model form of parent release, so you don't have to create your own. So it's simply a way to give you the tools you need to carry out the board's function and to assist the administration in making sure that it's doing it right. So that's simply an overview, a thumbnail of what the policy manual does. It's based upon national templates. It's based upon national standards. It's updated in order to assure that it complies with changes in the law. And as you join the policy service through the School Boards Association, you get the benefit of regular updates. You get regular advisories from the policy service. For example, I just sent one out. Joe distributed one for me within the last week on a couple of United States Supreme Court cases that came down dealing with student issues, so that you're aware. There's another one coming out on the board's authority to censure board members who misbehave or act unethically. So to the extent that these are guides for you to assist the board in the way it is carrying out its statutory duties, the idea is to keep you informed and to keep you current and to keep you compliant with the law. So to the extent that the manual is hopefully a useful tool for you. As an attorney for school districts over the last 4 decades or more, I have observed multiple school boards whose policies, you look at the policy and the date of adoption is, March of 1978. So to the extent that keeping up with policy updates, developments in the law, and making sure your policies are in compliance becomes a back burner item. Policy development and update is a back burner item when you have kids fighting in school, or guns, or car wrecks, or buses tipping over, or the roof on the gym is falling out. So all of those things divert your attention to more pressing priorities, but policy updates and keeping yourselves in compliance with your policies is important. As an attorney for school districts, I've also defended school districts multiple times in litigation. And one of the first questions that a lawyer who's suing you will ask is, where's your policy manual? Where are the regulations that support that policy manual? And when's the last time you were assured that it was updated and kept in compliance? And are you in compliance? Did your action in this particular instance that caused the lawsuit comply with the policy that you have on the books? And oftentimes it doesn't. And it's easy pickings for plaintiffs' lawyers if you're not in compliance with your own standards of operation. So that's sort of my opening speech about the policy service. I want to ask if anybody's got any initial questions about it, and I'd like to know where you want to go from here. Do you want to start reviewing policies, or do you want to simply set a schedule for reviewing the policy sections? There's 12 sections of the policy manual. And so it's going to take, I would say, the better part of a year for the school board to get through them all. And again, like I said, the model policy manual is 1,000 pages long. So it's kind of like eating the elephant, and you can only eat an elephant one bite at a time. So to the
So
extent.
Mr. Kennedy, we have sections A through C before us tonight to go over a little more in depth, is what my understanding is, that you're going to review so that we can eat that elephant one little bite at a time.
That's great. We'll do it.
So I have a question.
Yes, ma'am.
Question two. Go ahead.
Do you want to go ahead?
No, go ahead.
Mr. Kennedy, I used to call you John, but it's been a long time.
And you can.
The question I have is, are we looking at doing away with our current policies that we have made over the years? So we use the more formal policies to help us keep in line with all regulations and that come out.
That is entirely up to you. The concept of using this model policy manual is it is absolutely not intended to take your existing policy manual and chuck it out the window. If there are particular policies in a subject area that you want to retain, and they're in compliance with the law, and it is the board's preference to retain the old policy either as a substitute for the one that's in the model policy manual, or in conjunction with, as a parallel to a policy in the model policy manual. You're absolutely entitled to do that. So
Thank you. Mhm.
you know, the idea is, let's get you two things. Let's get you what you need and what you want.
And simplified. I can say for my perspective
Yes.
as a superintendent, I want something simplified.
Well, there's no sense racking your brain, because
I don't need
we're not
multiple.
reinventing the wheel. The wheel's already there. The wheel being school districts
Yes.
across the state, and the policies that are there. It's just a matter of tweaking it and conforming it to what we want for our school district.
Right.
Yeah, and you know, I agree with that. I believe in less is more. To the extent that you can say it,
Yeah.
you know,
Yes.
practicing as an attorney, I would supervise the work of younger attorneys, and occasionally you would get a lawyer who hands me a piece of written product, and it's 13 pages long, and I could have written it in 3. So to the extent that I am a believer in less is more, I'm a believer in keeping it simple if you can do so. That is a goal that I will try to focus upon in working with you on policy updates.
Can I just make a comment?
Yes.
Other question?
So I was just gonna make the comment when you're talking about the templates and the forms. So you said that there's a lot of templates that are already prepared and a lot of forms like parent releases and things like that. I think that does save a lot of time
Mhm.
if there's a template that's already there that you can kind of just use for your district, because I know that that can take a lot of time for people to come up with a form and decide what's legal and what's not legal and those things.
And just our directory, I mean, just as an example, it was about a year ago, we had a directory question. And our policy had so much verbiage in it that we had to redo our policy so we could comply with federal. I mean, like it was challenging because it's gone through so many revisions without it necessarily being legally needed. So I think less is more, and that's what we want to look at. And so when we look at, I'm going to go back to sections A through C right now.
Right.
And just kind of look at the components within there. I think what we need to do is, you guys as a board need to look at some of the statements that are said in there. And those are the things that could change, because it talks about some, like this initial piece is about the governance, right?
Right.
We know that legally we are governed by the school board and they have certain authorities, but it also talks in here in this initial policy, these are the things we believe. So as a board, you need to verify together, this is what we believe. We support this as a board. And then, because that's really not the legal part of it, but it is part of the whole governance of the policies in themselves. And so I think that's how we need to approach this. Is say, when we read those sections, I mean, I'm thinking that we're looking for your guidance as well, but we read them, we say, do we agree with that? And then we look at what's different in our own policies now, or what has to comply with a CBA for our CBA, for example. So what would need to be different or added, correct? Is that kind of the process we need to be taking?
I think you hit the nail on the head. The idea is we are proposing to you a different set of standards. And if you have a policy, I assume you have a policy that, the very first one in the policy manual is basically your mission statement.
Right.
In a school district, a school board needs a mission statement in order to set out broad philosophical ideas that the board intends to address as in implementing your statutory and legal duties. So having a mission statement is useful, absolutely not required by law. You don't have to have it, but it certainly, as a guide, is a useful construct in order to assure that you have an idea where you're going. You're getting in this vehicle and you're heading down a long road, but do you know what the guardrails look like? So to the extent that that's what a mission statement does for you, I think it's wise to have one. The one that's in this policy manual is 3 pages long, but it is not required that you adopt every single principle in this mission statement, and you can change them as you choose. If for example, you have a stronger belief in students and student welfare and student discipline, you can say it. And that mission statement can change from time to time. We have had school boards that have priorities for, maybe the next 2 years, you want to work on facility upgrades. You can say in your policies, our priority in the next 2 years is going to be facility upgrades and facilities management. You don't have to change policy to do that, but it certainly is something you might want to do by regulation or a simple policy statement saying the superintendent shall annually provide for a mission, a statement of the direct priorities under the mission statement for the next 12 months, if you understand what I'm saying.
Correct.
Okay. So every set of policies needs to be useful, it needs to be accessible to you, and it needs to be directed toward your needs, and your needs change. So to the extent that you're doing this right now, and I commend you for doing it, you are starting to eat that elephant. And it takes a little while, but spending the time, spending the board's time and the administration's time to focus on policy upgrades and policy development is very wise.
Any questions on this part? Okay, I see none.
So shall I just start going through
Yes.
Section
I think
A?
we're ready. Mhm. Please.
And I'm going to do this relatively quickly.
We have those for us or are they sent?
I mean,
Oh, we have them electronically.
I have them here. But
I can print them. I can print it for you, Mary Lou.
I just,
I got them right here. Leave it if you're fine.
I can do some prints. Hold on. Just let me send it to the right printer. It's just gonna take a second because it's like 100.
what do we need to do?
No, but he'll give us an overview of them. Yeah.
You just got online.
I can do it on the phone. We don't have.
He can give you one and then I printed one.
Okay,
He has his computer. So we'll be ready in just a second to go over.
It's probably it didn't.
Alright.
So anytime he references the section, you can just click it and it'll take you straight to it.
thank you. Okay, does everyone have them?
Yeah. Oh, you,
It's okay, go ahead.
go ahead, we're good.
Well, okay.
Okay.
I'm printing them for
Oh,
you. Okay, we're ready.
All right. Your policies begin with section A, and the first one is A-00, whatever. It's your mission statement. Honestly, I'm not going to read this. I don't think it's worthwhile to read it. It is a belief statement. It is a statement that what is the board's attitude and the board's mission in addressing student needs, teacher needs, principals, the local school board, the superintendent, and management principals as well. To the extent it's a philosophical statement, does not require any action by you to adopt this. It simply is the parameters of how the board wants to do its job and how it wants to impact the lives of your students, teachers, principals, administrators, and your community. So to the extent that that is important, you should read through these, and if they need to be tweaked a little bit to tie them down to how you do things locally, I encourage you to fix them. But it isn't it's not a big issue. So one of the things that you need to do is put a check mark next to these that may need to look later just to see. The next one is A0050, which is simply the legal name of the board. The Deming Public School District is your legally designated name. I would actually encourage you to check whether that is the legally designated name of the district, because it may not be. The way in which you can confirm what your legal name is to look on the front page of a bond issue of one of the bonds that the board issues, because legally, in order for you to borrow money, the underwriter is going to require the board's name to be legally correctly stated. So I'd look at one of your bond issues and just confirm that the school district is Deming Public School District. It may be Deming Public School District number 42, or it may be Deming Consolidated School District or something else. To the extent that you need to know that this statement is correct, I would encourage a quick check. The next policy is A150, which recognizes that the board has, excuse me, has a substantial interest in assuring that the public is involved in your operation and management, and that community involvement in education, excuse me, is critical in order to assure that your parents, your students, your staff feel that you are focused upon the needs of your community, and every community is different. So stating that you should assure that you pay attention to the fact that your educational program needs to be tailored to community needs is something that your policy here is intended to do. Parental involvement. A200 is a similar statement that you simply can't succeed unless you assure that parents buy into your program. You want to make sure that parents are actively involved, support, and interact with your staff to assure that the students are receiving the education to which they're entitled and to which the board feels they ought to be offered. Next policy is, this one's a little intimidating. It's non-discrimination and equal opportunity. This is your basic EEO statement, equal opportunity statement that assures that the board is committed to not discriminating and to equal opportunity under the law for all persons impacted by your programs. The number of legal references and cross-references at the bottom of the page is sort of a demonstration of how deeply those concepts intrude, I shouldn't say intrude, impact on a variety of programs within your school district. But when I started practicing law in the 1970s, I would say that 60% of these laws didn't exist. There was a proliferation of civil rights laws and regulations over the last 40 years that have brought us to where we are today. And those are intended to assure that people who receive benefit from your program aren't discriminated against or treated differently than they should be. Mm-hmm. So having a sound and comprehensive non-discrimination and equal opportunity policy right at the front of your manual is probably a good idea, so that the public, as it looks forward through your policy manual, can see that that is a main focus of the board's intent. The next one is A261. If you notice over at the right, AC-R, this is a regulation. So this isn't board policy, this is regulation. And it is the implementation guidelines for how you get to the goal of non-discrimination and equal opportunity. There's a complaint procedure, there are timelines, and a hearing procedure if people want to file a grievance saying that they have been discriminated against, and the board is required to address it and determine whether or not corrective actions need to be made. The next one is an exhibit. A281 is an exhibit for actually filing a complaint under that previous regulation. You simply fill out the complaint and submit it to the administration, and the administration is obliged to follow that complaint procedure to assure that the person who is filing the complaint either receives the benefits they're entitled to, or there's a determination that the complaint doesn't have any merit. Yes,
So
go ahead.
is that complaint, it's basically what we have now? Or it's a little
It's a
different?
process. So this R is the process.
Okay,
It's not the rule.
okay,
That's correct.
okay,
And I'm sure you
So
probably
it is
already have.
similar.
yes, okay,
It's just
You
not
may-
put like this.
okay.
Yeah, you may have a generalized complaint procedure for various categories of protected classifications, protected status like age, sex, race, national origin, sexual orientation. Those categories are entitled to state and federal protection.
Mhm.
Okay. A300 is non-discrimination on the basis of sex, and is basically the sex discrimination and Title IX policy. Are you all familiar with Title IX? Title IX is the federal regulation adopted by the U.S. Department of Education in the 1970s that assures that individuals of one gender are treated just as fairly as individuals of another. And Title IX has impacted particularly athletic programs significantly, but case law over the last 30 years has also recognized that Title IX extends not just to athletics, but to any other program that the school district operates in which students may be impacted by their gender. So to the extent that you may have a chess club, and the chess club has a rule that only boys are members of the chess club. I've seen that in writing. But that is an archaic rule and needs to be changed. And you basically can't have a chess club that excludes girls. So this is the kind of policy that is intended to address gender discrimination in all of your programs and activities, whether it's an academic program, extracurricular program, it's a sponsored program, or it's an athletic program. All of these things are protected by Title IX. And that policy goes through, 4 or 5 pages down to page 24 on my electronic set of the policies. There's a regulation that supports it as well. And the regulation is based upon the federal regulation that supports Title IX at the federal level. So it's required that the regulation be implemented by the governing body to assure that the standards set out in Title IX are actually implemented, and the people who are the intended beneficiaries of the program get what they deserve. And again, this is a lengthy policy or lengthy regulation. It goes for 10 pages. So, excuse me. there have been more and more claims under Title IX in the state and federal courts in the last 5 to 10 years. So to the extent that you don't want to have one of these complaints filed, you also do not want the Office for Civil Rights, which is the federal enforcement agency, OCR. There's an OCR enforcement division in Denver. And if OCR calls you up and says they're going to come down and do an investigation under Title IX of your athletic program, you're in trouble. Because they don't come down unless they're intending to find something. Anyone can file a complaint with OCR. All it requires is a parent who's upset about who got selected to be the captain of the girls' soccer team. And OCR is in your face, and they're probably going to be in your face for a couple of years. So honestly, making sure that your programs satisfy Title IX and that your Title IX coordinator is someone that you trust to actually implement change if it needs to be made is my advice, my strong advice. Some school districts have appointed a retiring football coach as the Title IX coordinator, who may not be as sensitive to these issues as he or she needs to be. I would discourage that. I would encourage you to have somebody as your Title IX coordinator who is truly interested in the kids and interested in fixing problems if they arise. So again, this is an important issue. It is a scary one because it is enforced by the Office for Civil Rights. And dealing with the Office for Civil Rights in my decades of practice was one of the more challenging tasks I had to deal with, because the investigators come in with a chip in their shoulder and they're going to find something and they're going to make you change stuff. And they want you to sign a compliance agreement that goes on for several years. So it is a serious issue and one that requires careful attention. Do you have any questions about that one?
I do. On the compliance issue, you talked about having to sign. You don't have a choice. You're required to sign that if they bring you that to you.
Well, no, you're not required to sign a compliance agreement with OCR, but if you don't, the Office for Civil Rights is entitled to go to federal court and sue you.
Okay.
And try to enforce their what they seem to believe are your deficiencies in federal court. And then if they file a suit in federal court, they're collecting attorney's fees as well.
Thank you.
You know, the concept of attorney's fees is one that you always have to be aware of. The number of the civil rights laws that entitle a complainant to seek attorney's fees has proliferated, and the attorney's fees begin to accelerate very quickly. I once had a religious discrimination case that a lawyer in Santa Fe, who was a pretty prominent, successful civil rights lawyer, filed a complaint in federal court. The school district settled the case in 28 days, and his claim for attorney's fees was $39,000 for a 28-day lawsuit. And the judge gave him 33.
Wow.
Basically, the judge gave him $1,000 for every day the suit was pending.
Yeah.
So, okay,
Yeah.
Excuse me.
We don't have any say whether it's okay or not, right?
That's right.
No, well, I mean,
No.
you know, there are cases that don't have merit, but if the case is one where you have not paid careful attention to compliance with a law like Title IX, and you get caught in that someone files a complaint, it is best to do what you can to resolve it as quickly as you can. And you do that with advice of counsel, and you do that in reasonable fashion. You don't have to give away the farm naturally, but
Right.
if you've been a little lax, it's going to come back and bite you. Okay, there's an exhibit which is a grievance form under Title IX on 0331. The next policy is 0450. It is commitment to religious neutrality. This again, religious issues, in my experience as an attorney, generate more emotion than just about any other issue. They become very hot, very fast. So in fact, the case I was just telling you about, the one that went on for 33 days and cost $30,000 in attorney fees, that was a religious issue because parents wanted to take their kids out of town for an extended period of time for a religious observation or a religious ceremony. And the school district said, no, you can't do that. We're gonna dock your kids for every day they miss. And so that became very heated very quickly. And so I encourage you to be cognizant of the protections that religion has under both state and federal law and constitution. So understand that this is a policy in your policy manual committing to assuring that students are treated fairly based upon their religion. Okay, A650 is educational philosophy and school district mission. Now this, in my mind, is sort of repetitious of the generalized mission statement that came at the beginning of the policy manual. So I'm not going to spend any time on it. I think the two work together. This is simply just a little more detail on how they work. So to the extent that that's something for you to read over and make sure you comply with, I would do that. Drugs, tobacco-free schools. This is simply a thumbnail that tells you where in your manual there are policies that deal with a variety of issues like abuse of drugs and alcohol, medicines for students, tobacco use, tobacco at public functions, so that you can make sure that your administrators are up to speed on what their authority is to enforce tobacco and alcohol rules. Okay. All right. Section B is school board governance and operations. Excuse me. I think I'm coming down with a cold, so I apologize. Fortunately, I'm not breathing on you. B050 is simply an opening statement basically on your operational goals that you have a responsibility to address community needs and opinions and develop strategies for responding to them. B100, the next one, is evaluation of the school board, the board's self-evaluation process. Now, this is more recent vintage. Over time, school boards in New Mexico have realized that it is necessary to do a board self-evaluation and to assure the community that you're paying attention to your own legal and ethical duties. And this policy and several after it provide you the tools for doing that. Now, you see this long set of bullet points. Those are the areas in which the board should be engaged in self-evaluation to assure that it's doing its job. The next policy, B131, is the evaluation form. It addresses the board's relationship with the superintendent, with the community, between board members, during meetings, board relationships with staff and personnel, the instructional program, fiscal management, general statements. All of these things are important aspects of the board's job and you need to think about them every so often. The board needs to look inward and assess whether or not the board is doing a good job with the community, doing a good job with between board members and with staff, assuring that the chain of command is followed and that the board only intervenes in staff and personnel issues once the superintendent has had a chance to address it. B150 is the board's legal relationship with the community. It really is, this is simply a statement of the hierarchy of schools in New Mexico. The New Mexico Constitution doesn't say anything about school boards. School boards are purely a creature of the legislature. But it is important that many of the principles that govern how you do your business are set forth in the New Mexico Constitution, and those need to dovetail with how state laws, the statutes that govern school district functions are implemented. This is simply a general statement of that, but it goes on further in the next one, B200, setting out the specific powers and duties and responsibilities of the board. B200 is a paraphrase of section 22-5-4, which is a section of the public school code that sets out your statutory powers and duties. And then the second page of this policy addresses how the Secretary of Education and the Education Department has carried those statutory duties out in the New Mexico Administrative Code. I assume you all know what the New Mexico Administrative Code is.
Yes.
Yes.
The Administrative Code is simply the state regulations adopted by state agencies to implement their powers and duties. And the Education Department has implemented a variety of requirements in the New Mexico Administrative Code for schools to carry out in order to ensure that you are doing what the state wants you to do. The legal reference at the bottom of this policy is 6.29.1.9 NMAC. NMAC is New Mexico Administrative Code. And that is where you will find these principles set forth to assure you that there is a legal basis for these standards. Now, 6.29.1.9 is probably a regulation that's 30 or 40 pages long, because it sets out the standards for excellence by that the education department has decided local school boards need to satisfy and address. So it is tough to wade through and find these regulations, but they're there. And so I would assure you that you need to follow them. One of the things that happened many, many years ago in the state of New Mexico is our state Supreme Court handed down a decision saying that a properly adopted state regulation has the force and effect of law. So it has the same compulsion, it has the same power to compel you to do what the regulation says as the legislature's enactments in the New Mexico Public School Code. So next policy is B0250, which is board member authority and responsibilities. It states right at the very beginning, a member of the Board of Education is a public officer that has no authority or power individually. That is an issue that comes up fairly routinely, and when board members step beyond the line of their authority. So having a board that is cohesive and a board that acts only through properly designated members or through the board itself, it really is important. So the board can delegate certain of its functions to the board president, for example, to take care of ministerial issues, routine issues between board meetings. But if it's something that's mandated by law to have the board take action, then the board can only do so as a body. Okay? Board member qualifications, that's statutory. I don't know, you'll know that we need to go over it. Person has to be a qualified elector, is registered to vote, has to physically reside in the district, and has to be a resident of the district on the date the board's proclamation calling for the election is adopted. This comes up fairly regularly, but it's also probably not going to take up a lot of your time. The oath of office, board members have to take an oath of office. The oath of office is set forth in B0431 and is drawn straight from the New Mexico Constitution. Article 20, Section 1 of the Constitution sets forth the oath of office for public officials. Board member resignation. There's no requirement that a board member sign a letter of resignation, but there needs to be notice to the board that the person intends not to carry out their duties anymore, and that raises the requirement that the board appoint a successor. And the reason that that's important is that the board only has 45 calendar days to appoint a replacement. And if the board doesn't act within that 45 calendar days, the power to appoint a successor falls to the Secretary of Education. So you need to have an effective date of the person's resignation so that you know when the time is running and you can act promptly to assure that someone is appointed to fill that position. If there is a majority of the board that resigns, then the Secretary of Education takes over that duty. Removal from office. There are a couple of provisions of public school code that provide for replacing a board member. If the board member misses 4 consecutive regular meetings, the board can declare that person's position vacant, and it can be replaced. If the person misses 6 consecutive regular meetings, the board member's position is automatically vacant. There is also a procedure in section 22-7-1. It's called the Local School Board Member Recall Act. And a recall can be initiated by citizens of the community filling out a petition and getting signatures to recall a board member by an election. So there's a special election used to determine whether the community wants someone removed from their office. The board itself has no power to remove a member, but the community certainly does. Unexpired term fulfillment is B550. Again, this is what I was just talking about. The board has 45 days to fill a vacancy. If it doesn't, the Secretary of Education does so. And if there's a majority of the members vacant, then the Secretary takes over that job. Board member gifts and donations, B0700. This is interesting because it's been codified in the Gift Act and in the Governmental Conduct Act that people who are receiving donations from people in the community, people with whom they may be doing business, cannot do so if it will affect the performance of their official responsibilities. So understand that there are statutes that govern size of contributions and the manner in which somebody receives a gift or a donation, and from whom that may affect your ability to continue serving on the board. Board member ethics. This is a fairly lengthy but abbreviated form of the Governmental Conduct Act. The Governmental Conduct Act was adopted by the legislature probably 15 years ago. But when it was adopted by the legislature, there was only one provision at that time that dealt with local public bodies. It was not intended to address the ethics of local public officials. Only one section dealt with that, and it was the procurement section. A public official couldn't be involved in a procurement that might benefit him or a family member. The Governmental Conduct Act was expanded, I think 6 or 8 years ago, to apply it to local public bodies. So all of these new ethical standards are mandatory on local public bodies, on school board members, to assure that individuals serving on public bodies are acting in the interest of the public and not in the interest of themselves or their family.
I have a question
Yes, ma'am.
on that. I think this comes up a lot during elections as a public member. I mean, like, for example, a board member contributing on their own, on your own card, you can contribute, but not contribute in exchange for special treatment. Is that right? Correct?
Would you do me a favor and repeat it? I didn't quite hear it all.
Okay. This comes up during elections about contributing to candidates.
Right.
For example, say our state legislature. If as a board member, contributing to the legislature's campaign without any ties, is that legal? But if we were to, if I contributed to the legislature in return for something to help my position on the board, can you
Correct.
differentiate that?
Yeah, no, I mean, you have the right to, if your son-in-law is running for the legislature, you have the right to contribute to your son-in-law's election campaign. But if you're contributing to your son-in-law's election campaign with the expectation that if he gets elected, you're going to get a zoning variance on a piece of property you want, that is a contribution anticipating the exercise of official duties by that legislator that's illegal.
Mhm. And that would approve even if you were just a friend and you were doing it, trying to get something back as
Yeah,
well.
I mean, yeah, if it's a personal benefit or a private interest that is the goal of the contribution, that makes it improper.
Thank you.
Okay. All right. Board member conflicts of interest is B0800. And again, as I said earlier, we are going to see, because of the intent by the legislature to try to address public corruption, public influence of individuals on the exercise of official duties by public officers. You're going to see more of these kinds of statutes that require the board to be as clean as a whistle. So the Governmental Conduct Act lists here a number of prohibited acts. The nepotism law has been in place for many years. The nepotism law, the intention here is that you not hire close relatives because the assumption is that if you hire a close relative, that close relative is going to do your bidding. And so you need to make sure that you try to be as clean as possible under all of these. They're basically ethics standards. So make sure that your official acts are not influenced by your personal or family connections. So these are simply the ways in which the policy is a way in which you can avoid those conflicts of interest, or if it is something that needs to be disclosed, there is a form at the end of this policy, an exhibit that allows you to disclose that so that the public is aware that you have either employment or connection that might affect your ability to carry out your public duties. Any question on that? My daughter and her puppies just arrived at the house, so you might hear some growling and stuff. Okay, B0900 is the board's organizational meeting. To the extent that the board has a statutory duty to appoint a president, a vice president, or secretary, that needs to be done. And it ordinarily makes sense to do that early in the calendar year to ensure that it's one of those things that is done routinely and isn't overlooked. There is nothing in the law that says you can't reorganize the board at any time. So to the extent that you may have an election of officers in January, you can have another one in February if you want, but that again disrupts the smooth transition of power over the board as time goes on. Board officers, I don't need to really review that. They're fairly straightforward. The last section of this policy on board officers 0950, it addresses surety bonds. There is a requirement that the board president and board secretary have a surety bond. Those surety bonds you get automatically through your insurance with the New Mexico Public Schools Insurance Authority. Honestly, my advice to you would be that I believe the surety bonds you get from the Public Schools Insurance Authority are for $7,500. We have had instances in which individuals have embezzled money from the school district in the hundreds of thousands of dollars and millions of dollars. And so my advice to you would be that you speak with your representative at the Public Schools Insurance Authority and increase the level of the surety bonds that protect you from misconduct by your administrators and board members, so that you can be protected in the event there is an embezzlement. We had a case up in the northeast part of the state, probably 10 years ago now, in which the chief financial officer of a very small school district stole $2.1 million. And the school insurance authority did pay on a $250,000 surety bond, but $250,000 doesn't do you much when you're out $2.1 million. So anyway, I talked with your insurance contact at the school insurance authority about what level of surety bonds they're willing to provide, how much it might cost. All right, the board superintendent relationship. There are a few things that are more important than the board's relationship with the superintendent. And I will just tell you that as a school attorney, if I got a call from the superintendent telling me that he was concerned and upset because the board is micromanaging him or her, and then I get a call from the board president telling me that the board is concerned because the superintendent isn't listening to the board, those are red flags. Those are code words for we got a breakdown in the relationship between the superintendent and the board, and we need to fix it. And whether it's fixing it by having mediation, by bringing in a third party, by whatever it might take, that is something that should be done right away, because things can go south so quickly. And once the board and the superintendent are at odds in the public domain, things just get worse. Board committee, I don't think I need to address that. You know, you can have advisory committees to assist you in carrying out your job. B1200, next policy, addresses how those committees are appointed. The school attorney, B1250, certainly you need to have a school attorney in this day and age. You know, I'm such a dinosaur that I've been doing this so long that when I first started practicing law, school law, you would go to a discharge or a termination hearing at the board level for a tenured employee and be very surprised if a lawyer showed up. Now you get the first thing you hear about when the principal was even considering non-renewing, terminating, or discharging an employee. The first thing that happens is you get a 5-page letter from their lawyer. So understand that lawyers get in your face so much sooner than they used to. So having a sound relationship, a productive relationship with the school attorney or a school law firm, and making sure that your attorneys are experienced and knowledgeable about school law is very important to you. It will save you lots of time and money. For consultants, this is really a generalized statement that you can use consultants to carry out your jobs, carry out the things you need to do. Makes sense to me, but it's really a procurement issue. You need to make sure that if you hire consultants, you follow the procurement code and carefully define the scope of their duties. School board meetings. We're getting into the open meetings law. The first sentence says that you need at least annually in a public meeting to determine what notice of meetings is reasonable when applied to the school district. That should be agenda item, action item number 1 on your January meeting every year to re-up your open meetings notice resolution. Not difficult, it simply has to be done. And it doesn't have to be done in January, but you know, just putting it on a regular schedule so that you make sure that you comply with the requirement that you adopt the resolution annually is something that I would commend to you. I don't need to go through all of the requirements of the open meetings law, but I will tell you that open meetings compliance is critically important. I have never, in my decades of practice, I've never seen a school board recall petition that did not cite as grounds for recalling a school board member violation of the open meetings law. It's always there. And it's easy to point to a meeting at which the board didn't quite get it right in order to give somebody the ammunition they need to file a recall action against a board member or multiple board members. So honestly, complying with the open meetings law is really important, and I would make sure that you all of you know it well, know how to comply with the open meetings law and do so. Executive sessions, closed meetings are provided for in the Open Meetings Act, and you need to be sure that if you go into an executive session, that you do it correctly. One of the things that I see still as an attorney is in the middle of a meeting, there'll be an item on the agenda to deal with personnel, and a board member will initiate a motion by saying, Madam Chair, I propose that the board go into closed session to discuss limited personnel matters. And you vote on it, and you go into closed session. That is not in compliance with the law. That would violate the open meetings law and give someone an opportunity to challenge anything you did as a result of that closed meeting. In order to close a meeting, you have to cite the basis under which the board proposes to go into closed session. So it would be, Madam Chair, I move that the board reconvene in closed session in order to discuss limited personnel matters. And then you have to include a second item, which is the topic the board is going to discuss in closed session. So I would say it has to be, I move that the board go into closed session to discuss limited personnel matters in order to evaluate the superintendent. Okay? So it has to be a two-part motion. It has to be the legal basis for the closed meeting and the topic to be discussed. You don't have to name names. You don't have to get into a lot of detail, but you need to at least raise the topic and put it in a motion to close the meeting. If you don't do that, you're not in compliance. Any questions on that one? B 1581 simply recites the exceptions to the open meetings law straight from the statute that allow you to close a public school board meeting. And recent changes to the law have allowed you, the last one on this list is purchase, acquisition, and disposal of real property or water rights. They've expanded that so that you can close a meeting to talk about either buying or selling school board property or water rights. And the reason for that is that if you have to disclose and have a public discussion of buying property and list on the agenda or in the motion to close the meeting that you are proposing to buy land in a particular area or a particular lot or a particular owner's property, guess what happens to the value of that property? It goes up and it costs you money. So that's why the legislature has decided that it is permissible to close a meeting to discuss those issues. Excuse me. Meeting procedures and bylaws, B 1600. Yes, you should have orderly meetings and you should have administrative rules on how you conduct your meetings. And that's basically what we're doing right here. So if you adopt these model policies, they give you the meeting procedures and bylaws you need. Notice of board meetings, you have to have an agenda posted to assure that the public knows that you're going to be meeting and what you're going to discuss. You have 10 days notice required for a regular meeting and 3 days notice for a special meeting, with the exception of emergencies. And the agenda needs to be published before the meeting as well. The B1700 gives you a template for what your agenda ought to look like. It isn't required that all of these items be on a board agenda. The only thing you're required to do is list the topics you're going to discuss, and once you assure that you give an adequate notice of the agenda, you can also amend it at the meeting, so long as it is not an action item. You can only amend the agenda to add action items up to 3 days before the meeting. Consent agenda, B1711. I like consent agendas. The idea of having a consent agenda is to address the routine kind of matters that the board has to take care of at each meeting, but not have to have a lot of discussion about it. So approving warrants, minor contracts, having the board, issue resolutions or commendations to employees, those sorts of things. Those can be done by a consent. Hey, Go on. Go on. Yeah. My daughter's got. Anyway. Consent agendas are a simple way of getting a lot of work done, as long as it doesn't require a lot of discussion. A board member can request that an item be removed from the consent agenda and then placed back on the regular agenda if there does need to be more discussion, and I've seen that happen many times. So understand that it isn't a mechanism for limiting public discussion. It's simply a mechanism for streamlining. Agenda preparation and dissemination. The superintendent normally prepares the agenda in consultation with the president. Excuse me. I'm pretty sure I'm coming down with a cold and my voice is probably giving out here pretty quick. So I'm going to try and get through most of this real quick. Understand that getting an item on the agenda should not be a political battle. That if one member, or this policy says any member desiring to place an item on the agenda can notify the superintendent of the item. The superintendent then decides whether or not it's going to be on the agenda in consultation with the board president. I think, honestly, that if the board president or the superintendent refuse to put such an item on the agenda, that two members ought to be able to get that item on the agenda anyway. And I will suggest probably an amendment to this policy that says that, because it should not be, agenda preparation should not be a way to keep board members from getting items up in front of the board for at least review and discussion. A quorum. This one's easy, B 1800. Quorum is the majority of the total membership of the board. So if you're a 5-member board, 3 is a quorum. I have actually had members tell me, well, we have a vacancy, so a quorum is 2. But that's not true. It is a majority of the entire membership of the board. There used to be 7-member boards, so the majority of those was 4. Next one is B 1850, rules of order. I'm really glad that this does not say Robert's Rules of Order. You have Robert's Rules of Order in your local policies as the rules of order for the conduct of your meetings and the conduct of your business. I would change it to this policy because Robert's Rules of Order is impractical for a 5-member board. It was created, Robert's Rules was created for the British Parliament back in the mid-1800s, and the British Parliament is hundreds of members and is way too complex. In fact, Robert's Rules of Order itself says it's not appropriate for use with small boards and commissions. So you might check to see if you have that kind of a throwback in your policies. B 1881 is simply an exhibit with a variety of types of motions that give you a thumbnail on what kind of a vote is required, whether the motion can be amended, whether it can be debated. It's simply a way to structure your business so that you know, for instance, if you want to suspend your rules, you're going to need a 2/3 majority. That's not statutory, but it's probably wise, because making it more difficult to suspend the rules is I think, an intelligent way to operate. The public doesn't want you suspending your rules all the time. So to the extent that you only do it when it's an important issue. Voting method, since the Open Meetings Act has been amended, is now a number of years ago, probably 15 years ago, that requires that the vote of every member be recorded in the minutes. This is sort of a fairly straightforward recitation of that requirement. Minutes, B 2100. The minutes in the Open Meetings Law simply require that the minutes recite the motions made and the action taken and how each member voted. That's all the Open Meetings Law requires. However, there is a little more meat to it in this policy, and it simply is a way for people reviewing past meetings to know what actually occurred there in a more substantive way. I actually have been practicing long enough that I can remember interacting with the board secretary who took dictation and prepared verbatim minutes. And that's not necessary and probably not even practical anymore. But to the extent that this is an important way for you to guide your administration and your superintendent on what you want the minutes to look like, I would be sure that that gets carried out. The last sentence, or the last paragraph, talks about the minutes being filed in the superintendent's office and are available for inspection by any citizen during regular business hours. Very important. Also, the minutes should not be removed from the superintendent's office. So to the extent that you need to make sure that your minutes book is controlled, is properly maintained, and not taken out of your office for someone to mess with, basically. Public participation at meetings. Now, the Open Meetings Law 10-15-1, cited down in the legal reference, doesn't require public participation at meetings. What it says is the public shall be invited to attend and listen to the deliberations of your meetings. Attend and listen is all they get by law. That, however, is unlikely to be satisfactory to most communities. People want to be able to stand up and address you. So this public participation at meetings policy is intended to assist you in allowing that, but not allow it to get out of control. It calls for recognizing speakers, maintaining proper order, and putting a cap of 5 minutes per speaker on it. You can adjust that 5 minutes to 3 if you wish, or 2, but having some cap on the length of time somebody addresses the board is useful. It's also important to assure that you know the last bullet point, personal attacks on board members or personnel are discouraged. It used to be that the board president would announce at the beginning of the public comment section that no personal attacks or, criticism of the board will be tolerated. That is no longer permissible under case law across the country that basically says You can't violate people's First Amendment rights by not letting them say what things that might be unpleasant to hear. So understand that personal attacks are permissible as long as people don't violate normal rules of civility by threatening or becoming violent. So that you can impose limits on it, but it also have to be reasonable limits. B2181 is a form for addressing the board. News media meetings is B2200. Certainly you should notify the local media that your meetings are being held and provide them an agenda so they can come to the meeting if they choose. Board policy. This is what you're doing right now. You are considering board policy and amending board policy. The policy adoption provision B2600 calls for a first meeting at which the proposal is presented and a second meeting at which it's discussed and acted upon. I have encouraged boards for years that you don't need 3 meetings to adopt a policy. It just becomes too cumbersome. So to the extent that a first meeting for review and a second meeting for action is probably wise and probably enough for your community. B2650 policy review and revision. Again, reviewing your policy manual is a back burner item normally. It isn't something that you consider to be a high priority. And so to the extent that state law, state regulation requires you to review your policies annually, I would recommend you do so. You need to comply with that, but understand that it is almost always a lower priority than the other pressing issues that you have to deal with. So make sure that you give it the attention it deserves, because your policies need to be current, compliant, and up to date. But also understand that you're going to have more pressing issues that might divert your attention. And so you need to just tough it out and keep it up there. 2661 is a regulation on policy review and revision. I'm not going to review that in detail. Review of regulations, 2750. The superintendent adopts regulations to carry out your policies. I would follow this policy because your regulations are really where the meat of the action is in a lot of cases, and the board needs to know about those regulations. So to the extent that if the superintendent is adopting administrative regulations, I would put that on, at least on a consent agenda item, so that the board can review it and make sure that it is at least aware that there's a regulation carrying out a policy that is adopted. Communication and feedback. There's a need for the superintendent as your chief executive officer to assure that the community knows what your policies are and has an opportunity to react to them. You don't have to have a committee of community members to adopt a regulation or a policy. You don't have to have anything more than the policy drafted and the board act upon it. But if you want a community that isn't on the warpath for you, you need to make sure the community has a sense of how you're doing your business. And so when regulations are adopted, they need to be at least provided for the community to review and react to. And that's normally the superintendent's job to put it out for review and reaction. Does anybody have any question about that? 2881, 2811 is a regulation on that one. 2831 is a form for people to propose or for the administration to direct how your policies are being changed once they have been changed. Suspension and repeal of policies. It is, excuse me, it may be necessary periodically to suspend a policy. You know, for example, your policy on adopting changes to your policies. It may be necessary to suspend that policy in order to meet some legal requirement. It may be necessary to suspend policy on 2 readings simply because you have an urgent action that needs to be taken, that if you don't take it, the board is disadvantaged. So allowing the board to suspend or repeal a policy without a lot of administrative procedures is wise, as long as it doesn't violate some statute or regulation. For communications with staff members, B 3050. You know, really, your only employee is the superintendent. So the board should not be having regular communications directly with employees. I know that that's not practical. It's going to happen. And I would expect that board members will occasionally want to visit the schools, check into classrooms, sit in the back and just see how things are. But I would never, if I were a board member, enter a school building without notifying the principal that I was coming, check in at the principal's office before I went anywhere else. And if the principal wants to accompany a board member who's touring the school, that should be tolerated. So assure that there is a need for the board to know what's going on in your sites, but also there's a need for the board to let the superintendent know and the site administrator know that that's happening. Okay? You should not be having direct communications with staff members without board and principal knowledge. Board communications with the public, B 3100. Again, if you are in the grocery store as a board member and someone comes up and buttonholes you about a complaint about a 2nd grade teacher, your response needs to be, have you taken that up with the principal? Yes, I have, nothing happened. Well, have you taken that up with the director of instruction? Yes, I have, and nothing happened. Have you taken that up with the superintendent? Yes, I have, and nothing happened. And that's typically the response you're going to get. Excuse me. The board should not be taking up directly concerns by parents or community members or staff members unless the board has interacted with the superintendent first and assured that the superintendent has dealt with it in some way. So be assured that if you become, as an individual board member, the earpiece for everyone in the community that wants to complain about the schools, your phone's never going to stop ringing. You're going to be getting calls at 2 o'clock in the morning. So to the extent that you need to be cognizant that the chain of command really does serve a purpose, let the community know that as well. And this policy is intended to give you the tools to say to somebody who, approaches you at Walmart and wants to bend your ear about a complaint. You can say, we have a board policy on communications. It needs to be followed. So you need to take this up either with your site administrator, the superintendent, or maybe the Title IX communicator or Title IX coordinator or the coach or whomever it might be. Confidential communications. This lists the type of confidential communications that the board may actually be engaged in. The point I would like to make is that the board needs to be aware that individual members have no authority to disclose confidential information unless the rest of the board consents to it. It can damage you. It can increase the scope of liability that the board may be exposed to in litigation. It is unethical under the Governmental Conduct Act. So be aware that breaching confidentiality can harm the board. It can harm individuals. It can harm employees, and it can harm the public. So can't emphasize that enough. Board member orientation and a handbook. I think this is very important. New board members have no idea what boards do for a living. Some may, but many don't. So giving the tools to a new board member by an orientation or by training or by a handbook to allow the person to get up to speed on the business of the board is critically important. And that's not just how boards operate, but it's meeting with the board president to find out what the pressing issues are that are going to come up at the next 3 board meetings, or meeting with the superintendent and the finance director to get a clue what the budget does, because you can't just look at a school board budget and have a clue what it really is. So understand that new board members need to be a sponge, and you need to provide the water to fill that sponge. Board member development opportunities. Again, within the limits of your per diem budget, your board members need to attend workshops in order to get better. So encourage it. This one's the same: conferences, conventions, and workshops. Compensation and expenses, that's the Per Diem Mileage Act. The legislative program, the School Boards Association has a lobbyist who lobbies for public school boards in New Mexico. She is a former board member of the Milwaukee Valley Schools, and she's very good. Her name is Lily Mae Ortiz. If you have an item that you want the board to address or would like to have the board receive some legislative assistance with, I'd call Joe Guillen at the School Boards Association and have him put it on his legislative list if it's an appropriate thing for broad impact. And Lily Mae Ortiz will take that up with the legislature. School board memberships, you can join associations, and I encourage you to do so. And I encourage you also to go to trainings and become better board members. Liaison with school boards associations, again, same thing. Administrative goals and priorities. the board needs to, I would say the board needs to have a meeting every year to establish goals and priorities for the following year. I would recommend that the board do that early in every fiscal year. Because once you know what your budget is, then you can establish financial priorities and administrative priorities to carry those out. So I would recommend that the board have particular meetings to establish your goals. And you shouldn't give the superintendent more than 2, 3, 5 goals every year. Because other than that, if you do, the administration is going to get bogged down and can't do it. And that then will affect the superintendent's evaluation and the board's satisfaction with the superintendent. So I would recommend you spend the time to set priorities and spend the time to give the superintendent the direction the superintendent needs in order to go back to his or her office and carry those things out. If you are concerned about whether or not those priorities are being adequately addressed, set times for follow-up reports at your meetings. Have the board report to you every 2 months about how a particular project is going. And then you'll know. The superintendent, C100 is the policy on the superintendent. All of these are duties and responsibilities set by state law and regulation. And there didn't used to be a statute on the superintendent's powers and duties. There is now, but understand that the superintendent has a huge set of priorities and has a huge plate full of tasks. So I frankly don't know how a school superintendent can do the job that is required, given all the requirements by the feds, by the state, and by the school board and legislature. So to the extent that meeting with the superintendent and assuring that the superintendent understands what the board considers its needs and priorities is critical, and I would do that early on every school year. C150, qualifications and duties of the superintendent. You as the board can specify what you want a superintendent to have in terms of qualifications. The superintendent certainly needs to be licensed and needs to have the appropriate level of experience and responsibility to perform the duties on behalf of the public school board. But you can set particular requirements for the superintendent's qualifications. If you've had a bad experience with the superintendent who wasn't knowledgeable enough, you can say we require that our superintendent have at least 3 to 5 years of experience as a superintendent in a school district of such and such size, that kind of thing. So understand that setting duties and setting qualifications is one of your tasks. Evaluation of the superintendent. Again, this policy says that the board is going to receive the evaluation instrument no later than December 10th, schedule a meeting no later than December 18th, and start the process. I would actually start your superintendent evaluation process earlier in the year, at least to the extent that you meet informally with the superintendent to say, we consider the following 3 to 5 goals to be important goals for the board, for the superintendent to address this calendar year, this academic year, and start from there, and then move it on to the more formal superintendent evaluation process. The policy gives you an evaluation form. in C 631 goes on for 4 or 5 pages. C 900 allows the superintendent to delegate responsibilities unless there's a limitation by statute that the superintendent can't do so. Administrative councils, cabinets, and committees, again, the system doesn't function unless you get assistance from others. There is a requirement for advisory councils in states in the public school code. But buying in, getting the public to buy into your program is important. And while it may be difficult to deal with paper programs on an occasional basis, you've got to have public support the efforts that the school district is making to do its job. Principals and building administrators, this is pretty much from state regulation. I'm not going to repeat it. Principals have a lot of responsibility and need to carry it out. School-based management, school councils, these are statutory, and to the extent that the legislature has decided that school districts need to have more input from your constituents, this is one of the ways they've done it. So I'm not going to talk about it too much. School-based management is again school councils. Video surveillance, you have the power to have video surveillance equipment on your property. And understanding that, you know, your responsibility is not to have video cameras in bathrooms or anything like that, but having video surveillance on your campus to protect against vandalism and damage to your facilities can save you money. Policy implementation, it's the superintendent's responsibility to carry out the policies, and you need to have those policies complied with and implemented. That is an evaluation item for the superintendent. Handbooks and directives. There are so many handbooks, manuals, and guides
Yeah.
that are created throughout your system. But know that the superintendent has the responsibility to assure that he or she provides enough guidance to your staff that they can be more effective in doing what they're supposed to do. Regulation 2161 says that any of those handbooks and guides need to be reviewed by the principal or supervisor and forwarded to the superintendent for approval prior to printing and distribution. Really smart to do that because, again, if a site administrator is imposing on his or her staff particular requirements in a manual, and that manual isn't in compliance with state law or school board policy, maybe the superintendent will catch that. Hopefully the superintendent will catch that. Administration in the absence of policy, C2200. You know, you just can't anticipate all the things that are going to hit a superintendent on a daily basis. And you should just hope that your superintendent has the common sense to know how to deal with situations that aren't covered by policy, that are going to come up about every 3 hours. So to the extent that there's a responsibility of the superintendent to be nimble, fast on his or her feet to deal with unanticipated issues, That's one of the things that the superintendent does for a living. But it's also the superintendent's responsibility to let you know if something that's come up needs to be addressed more formally and have either a policy or a regulation written to deal with it. New things come up every day, and you need to be sure that the superintendent lets you know if you need to be making it more formalized. Administrative consultants, you know as well that consultants can help your administrators to do their job. The annual accountability report is required by statute. So this simply says that. And we are to the end of section C. And I am going to stop talking now because my voice is just about gone. Any questions? Let me ask you this. Has this been useful to you?
Yes. I think from my standpoint, I think it's useful in the fact that going over them, even though it was fairly quickly as we had to, it's now our duty to make sure we understand and we follow our policy manual. If we don't, then we're in big trouble.
Well, and that's, that's one of the superintendent's jobs is to make sure that if you have a policy or a regulation, it's being followed and it's being followed the way it was intended.
Mhm.
Any other questions, concerns, complaints?
I just have a comment. I was gonna say that what I noticed is I was going through the old policy manual and then the policy manual that we were here, and it's very different, isn't it? It's
Even the layout.
yeah, it's
Yeah.
it seems like it's much more thorough. The one that's here, the that we were looking at, it's got a lot more detail and a lot of things that I think are missing in the other one.
So one of the questions I had though, as I was looking through it,
Mhm.
because some of it is, the policy itself is the compliance, where
Right.
there's the regulation and which are the procedures. Would it be appropriate to separate those in terms of having two separate documents, or do you not recommend, because that makes for a very long document, like if you
Oh, yeah.
only need to see something for a particular section,
Or if
as
you only-
opposed to, I don't know, it was just a
or if you
question I
just need a
had.
Form, if you're looking for that
Right.
form.
So I don't know, what are your thoughts on that?
I think it would be perfectly appropriate to separate the regulations out into a separate document. No, there's no reason the regulations have to be in the policy manual. This policy manual, which, it came down from, the National School Boards Association. Don Williams, who was my predecessor as policy service director, adopted it in Arizona and brought it to New Mexico as a template. But it isn't, it's not the 10 Commandments. It's not cut in stone. So to the extent that however it can facilitate making your job easier and more effective, we should do it. And if taking all the regulations out of the manual, which is 1,035 pages long, would make it easier, I'd say go for it.
Okay.
Yeah.
Any other comments? Questions? We don't have a test tomorrow, do we?
I think your test was simply sitting through this for a couple of hours.
Well, no one left, so I guess we all get a,
Your
pass on
endurance, your endurance is commendable.
Oh, dear. So any other comments from the board? No, I think we're all just letting it seep in.
Right.
And it's something it's very important to us though, because sometimes school boards can overdo what we are, what is our job rather than really follow what we should be doing.
Sure, and if this all sinks in a couple days and you want to do this in a different way, simply let me know. I mean, the getting through a massive set of policies like these are, it is like eating the elephant, and you can only do it one bite at a time, but you can also do it differently if you wish. And I'd be open to whatever is most useful to you.
Thank you.
Thank you.
How many times have you done this year?
How many times have I done this for other districts?
For other districts?
About a half a dozen.
Yeah. Well, you get a star.
Yeah, Joe Guillen from the School Boards Association is attempting to make sure that every school board has a current compliant set of policies. And I think that's an appropriate goal. But, like I said earlier, adopting policy and reviewing policies is normally a back burner item. You have
Yeah.
much more important priorities. So I commend you for doing it, and hopefully we'll get through it.
We will.
You just let me know how you want to proceed from here.
Okay,
Thank you.
Thank you.
thank you very much.
Okay, then I'm going to sign off. It has been a pleasure talking with you all. You asked good questions, and we'll get through it, and hopefully it won't be too painful.
Okay.
Okay,
Thank you. Thank
Good
you.
Thank you.
Good night.
good night.
Nice.
Hmm. Okay, well, our next item is recommend of adjourn for works from the work session. So we don't have to have a motion. We can just
To
say
adjourn.
to adjourn.
Yes, you do need.
We need a motion to adjourn.
I make the motion that we adjourn.
Okay, do I have a second? You have a motion and a second. Would you call the roll?
Yes, ma'am. Mr. Orozco?
Yes.
Mrs. Paez?
Yes.
Mrs. Cameron?
Yes.
Mr. Crowe, yes.
Okay, we are adjourned. Thank you, everyone.